Welcome to the PCO Podcast. In this podcast, we share information and tips with international companies that want to establish themselves in the Netherlands. Information about the Dutch labour market, trends and topics, laws and regulations, Dutch tax and legal information, sales and marketing strategies, schools for the children of expats, and much, much more. In each episode, we will briefly address a specific topic. PCO, Pro-Job Company Onboarding, is a network of cooperating Dutch and international companies that support immigrating international companies with their onboarding in the Dutch economy and labour market.
My name is Els Brouwer from Pro-Job Company Onboarding. And our guest of today is Martyn, lawyer at Höcker Advocaten in Amsterdam, the Netherlands. Their expertise lies, amongst others, in the field of employment law. And today we are recording through an online connection. Martyn, welcome in the PCO Podcast. Employment law in the Netherlands regulates the relationship between employers and employees. As an introduction, can you tell us a little bit about Dutch employment law in general?
Hi, Els.
Hi.
First of all, thank you for having me in your podcast.
You're welcome.
Yes, I can tell you about some principles of Dutch employment law. So first of all, there is a compensation for inequality. The employee is deemed to have a less advantageous position than the employer, and therefore requires protection. That's the idea behind this principle. So although many take the view that this principle does not apply anymore to all employees, especially the higher educated ones, Dutch employment law is heavily influenced by this principle. So for example, apart from a couple of exceptions, an employee is protected against dismissal, and the employer should obtain court approval for termination of employment contract, and this generally requires a file that shows a reasonable ground for termination. And in many other European countries and also abroad, this is different. So maybe as a further example, fair employment practices, that's another governing principle. Dutch employment law literally contains a rule that employer and employee should act as a good employer and a good employee. This is important because many rules under Dutch employment law are not set in stone, so they leave room for interpretation. And this is, for instance, when fair employment practices become relevant. A couple of examples. In case circumstances at the company change, employer may ask an employee to perform other work outside the scope of their job description. Or, other example, in case an employer has agreed on a discretionary bonus and simply refuses to pay a bonus, arguing, well, hey, this is discretionary, Dutch law prescribes that an employer clarifies how the employer has come to the decision, even if it is not agreed between parties.
And the poldermodel, that's also an example, I think.
Yes, well, certainly. The poldermodel, that's of course a Dutch word, is typical Dutch. It is common that the social partners, so the employers' associations and trade unions, have a lot of influence on the introduction of new rules and regulations. So not merely when it comes to negotiating collective labor agreements, but also on the introduction of new employment legislation. And on a micro level, it is common for employers to consult with employees on their work rather than taking a more directive approach. So when landing in the Netherlands, it is very important to assess whether your activities fall under such a collective labor agreement. As less and less sectors, including IT and the software sector, for instance, are regulated by collective labor agreements, the influence of unions is decreasing. The more and more employers try to come to collective employment conditions with their works council. And the works council is not typically something you would have to look into immediately when setting up office in the Netherlands, as a works council only needs to be established in case a company employs 50 employees or more.
And what kind of working relationships are there in the Netherlands?
So I think you could distinguish four main groups. Employees, people who have straightforward employment with their employer. Then you'd have independent workers, so people who are self-employed either through a legal entity or through a one-man business. You'd have temp workers, that's what we call uitzendkrachten in the Netherlands.
Mm-hmm.
And then you have payroll employees. And there's also contracting, but that's not considered to be employment in the Netherlands. The status of an individual is important because it determines what legal rights and obligations apply to that worker. And in addition, an individual's status also determines their tax and social security treatment.
Martyn, can you tell us, are there any requirements for foreign employers to work or to hire foreign employees?
So if an employer wants to hire a foreign employee in a legally valid manner, several requirements have to be met. First of all, the foreign employee has to be in possession of a residence permit. Secondly, they need a work permit. Employees with a Dutch nationality and employees from one of the countries of the European Economic Area and Switzerland are exempted from these rules. So your to-do as an employer setting up a shop in the Netherlands is to liaise with both an advisor on migration law as well as on employment law if you want to employ foreign individuals.
And does a foreign employer need to establish or work through a local entity to hire an employee?
This is a question we often get. And do I need to actually set up a legal entity here before I can hire employees? Well, this is not the case. And foreign employers can hire employees in the Netherlands either through a local entity or through a foreign entity that they already have established in their home country. You need to take into account that you are dealing with local legislation, so Dutch law, and that it is advisable to get familiar with these rules before offering any work contract to an individual. Before deciding on how to structure their business in the Netherlands, foreign employers are advised to consider the tax consequences as well. We have to look at employment legislation and tax legislation.
Yes, thank you, Martyn. I think this is very valuable advice. And in addition to the rights and obligations deriving from the employment contract, are there other sources the employer has to take into account?
Yeah, certainly. I already mentioned the collective labor agreements, so written agreements between employers and trade unions that govern wages and employment conditions. In Dutch, collectieve arbeidsovereenkomst, and so in English, collective labor agreement. A collective labor agreement is legally binding on the parties and its members. The employers who are a party to the collective labor agreement must apply it to all their employees, irrespective of whether those employees are trade union members or not. The Minister of Social Affairs may decide that such a collective labor agreement or a part thereof is applicable to all employment contracts between employees and employers in a certain type of trade or industry. So this is really far-stretching, right? The government basically says, well, these rules are applicable to all employers in the branch. And this is, of course, something you really need to check before you start your business in the Netherlands, because it impacts the room you have to negotiate the terms and conditions with your employees. Furthermore, Dutch employment law includes a number of mandatory employment benefits such as holiday allowance, minimum wage, minimum holidays, so days off, and also continued payment during sickness for a certain percentage. And especially this last topic, continued payment during sickness, is worth mentioning. If an employee becomes incapacitated for work, he or she will remain entitled to continued payment of wages for a maximum period of 104 weeks, so 2 years. This is really a long period compared with a lot of other European countries. Statutory minimum obligation for the employer to continue payment of the employee's salary during the first 52 weeks of the employee's illness amounts to at least 70% of the most recent gross base salary. As of the 53rd week of illness, so the second year, employee remains entitled to 70% of the most recent gross base salary, with the optional understanding that this salary does not exceed 70% of the maximum daily wage. So this is maximum daily wage in the Netherlands is about 4,600 euros gross on a monthly basis. So a lot of rules are based on European legislation. Foreign employers who are based within Europe might recognize some of the legislation in the Netherlands from their own country as well.
Well, Martyn, I think we have come to the final question, and you have given us a lot of information. Thank you for that. What kind of employee representation is there?
So I've already told a little bit about the polder model and the fact that you, as an employer, you often negotiate, talk, consult with employees. I think the most important example is the employee representation in the form of the Works Council. According to the Dutch Works Council Act, a company maintaining an enterprise where, as a rule, at least 50 employees work, is obliged to establish a Works Council for the purposes of consultation with their employees. The Works Council has several rights, and they have the right to be informed on certain topics. They have the right to advise on certain strategic topics, such as reorganizations, and they have the right of consent to the introduction or change of certain important employment conditions. So this is something to really take into account because it's, I would say, typical Dutch not adhering to those rules can have a big impact on your company. And the second example of employee representation is, of course, the existence of trade unions. They still play important roles in case of collective dismissals, strikes, collective bargaining with respect to the collective labor agreements. And trade unions can also represent the individual interest of employees. So these are the two main examples of employee representation in the Netherlands. Of course, when you actually are considering setting up your business in the Netherlands, my approach would be to discuss these topics more in depth with an employer, so that the employer really knows what they're up to.
Did you think it was informative and interesting? Then we hope you will listen to our next episode as well. If there is a specific topic you want to be informed about in this podcast, you can send us an email to companyonboarding@projob.nl, and we will invite one of our experts in the network to share his or her expertise. The PCO Podcast is hosted by Els Brouwer, Marieke Kramer and Esther Werneke from ProJob Company Onboarding. If you would like to listen to more PCO Podcast episodes, please visit companyonboarding.nl.